Good morning, this is me, Jimmy, on a 30th of October. Some information I want you to pass around is the destabilization of rent-stabilized buildings. The, they're giving out one-year leases and termination of two-year leases, and the one-year lease is the destabilization part where they were not offering two-year leases. Now, the problem is that in the rent-stabilized building, the landlord was, upon purchase of this building, most of the new landlords are doing this. Upon purchase of this building, they got a tax break for keeping it rent stabilized, and now that they have gotten that tax break, they are destabilizing the tenant. In other words, they're violating the contract. They're breaking a contract which they sworn to uphold. I call it eviction fiesta as well as it's an entrapment where the landlord's returning the rent, and that's a no-no. In some cases, they return the rent, but this is the point of attack is that the first step is they'll send you a notice of petition of renewal of lease with the intention to recover the possession. The second one they'll send you a petition of notice of non-payment. The third one is very critical, but this is when they're making a move to change attorneys and put this case into the hands of an attorney firm that is we call specializing in evicting tenants. They call it a petition of notice of holdover residency. In other words, you consider the holdover. And once you go into the position of being a holdover, it goes into the hands of a law firm called Barat and Goldstein. Robert Goldstein, the founder of this company, he sits on the board of communication of housing improvement programs. He also sits on the landlord-tenant civil court case committee. He sits on the New York Lawyers Association. He also sits on the Housing Court Advisory Council. He also sits on the body that select new housing court judges. He also was a two-term in Nassau County Rent Guidelines Board. He also gives literatures to the court administrators. He also sits at the Rent Stabilization Association. And the court will not consider the case to be frivolous, because if you do consider it to be frivolous, it goes into the hands of the tenant have a right to file for harassment. So what the court does to protect Robert Goldstein, because they have such a good relationship going, they block this by ignoring and allowing it to go through a discovery and inspection process, which is Article 31. Article 31 in the 240.220 is the same criminal court Article 240 on discovery on demand, where in criminal cases they take criminals under this process to get all the information they can before prosecution. And the problem is that tenants are not criminals. So what they did, they took the same law and they just changed the number from a 240 to Article 231, Rule 3120A in particular. This law violates 27 of the Constitution amendments. Now, New York City Housing Court judges will tell you that it seems like it's an invasion of privacy and confidentiality. Well, it is an invasion of privacy and confidentiality. And not only that, it violates the Fair Housing Act. In the process of violating the Fair Housing Act, this law, the eviction Ponzi, main target are senior citizens. Now, once the landlord refuses to give you a lease, he also, if you are a senior citizen, you cannot get SQUE, the senior citizen rent exemption, or the disability rent exemption. You can't get that because you need a lease to get that. And what the landlord want to step further is they have refused they have terminated succession right. Once the first thing a judge would do is terminate those succession rights. Once they terminate the succession rights so that your children and no one related to you could live in that apartment, then the eviction Ponzi began. You're out. And we're here to stop it. There's no way you're going to get back in that building. Once the judge does this, as a compliment and a favor to Robert Goldstein and the law firm, because of their brother, they go golf together, they go bowling together, they have dinner together, they break bread together, whatever they do, it has to stop. And this is what we're here to do, clean up a mess that's been made. And New York State Supreme Court recognizes the law firm as racketeers and co-conspirators, but they refuse to disbar them, the judges as well as the law firm. And that is what we're here to do. It sounds like it's hard, but it's not, because because I don't give a damn about them. All right? Once again, this is me, Jimmy McMillan, from the Rent Too Damn High Party. I hope you pass this around to everyone you can. This is very critical information to those who rent. If you have any questions, go to my website at rentis2damnhigh.org. Just email me at email me at damnrentparty. I will try to leave information in the description, so you need this information. Election is Tuesday, November 5th. And as I see that we're about to make the same mistake again, the people who we're about to vote for, de Blasio or either Lodo, it's like not voting at all. All they're doing is changing the guard, but the administration remains the same, and things is about to get worse. Rent is too damn high.